So good afternoon to everybody. I am really glad and honored to be here. It has been a very joyful event, and I also like very much the speakers before me, and of course I like the view. But let's start with my small presentation, the last one that is between you and the nice evening and the dinner. I start with some numbers. First of all, Estonian population, I don't think it's a surprise for you. It's not a big country. It is perhaps the same amount of people living in Estonia that it is in Latvia. It's not a big economy, and that means that we don't have that many intellectual property cases. And here I have put for you some numbers, so you could see how many patent applications we have had during recent years, how many registered patents, how many trademarks. And you can see during the last years we haven't had any applications for geographical indication protection. In fact, we have only 4 registrations on that area in Estonia still, and no registration for layout design. So this hasn't changed during last years. So in 2014, slight change in the number of registered patents. 2015, almost the same numbers, 16 and 17. So you can imagine, taking into account these numbers, that we obviously cannot have that many patent cases. And so far, we haven't had many design cases as well. There are some cases, but they're still pending, and that's the reason why I'm not going to talk about these cases. So, general overview. Who are solving intellectual property cases? There are 2 possibilities. The first possibility is a civil court, and we also have a board of appeal. And this is an independent pre-trial institution that is solving appeals filed to contest patent office decisions. Sometimes they are solving disputes between interested people and applicants and so on. And if the parties do not agree with the decision of a board of appeal, they can take their case to the court, to the civil court. But it's not often they do it. So one can say that the board of appeal takes away a big amount of the cases that never end up in court. And the board of appeal is working on the Ministry of Justice, and there are 10 members at the board of appeal. So here you can see how many cases the Board of Appeal has solved during last years. Not many. The number was slightly increasing in 2015. And then in 2016-17, the number has decreased again. And you can also see that most of these cases solved by the Board of Appeal were trademark cases, and only very few of them were patent cases. Now, let's come to a court system. It's not a big surprise for you. We have 3 court instances. And all the intellectual property cases at the first instance level are solved by the court where I am working. And this is the Harju County Court, and this is the largest Estonian court that is situated in Tallinn. And we are basically governing the area of Tallinn and the northern part of Estonia, but intellectual property cases are specifically mentioned in the law, that these cases are solved by our court. And then we have, of course, 2 courts of appeal, and then we have 1 Supreme Court with 19 members. And separate from that, we have also administrative court on a first instance level, but there is 1 court of appeal for all 3 issues, criminal issues, civil issues, and administrative issues, and of course 1 Supreme Court. So when I have mentioned here, we have that we have 3 specialized judges currently working with intellectual property issues at Harju County Court. This is not something that is not prescribed by the law. This is just as a result of a work division between judges who are working at our court. So this year it is 3 judges. Next year it will be 2 judges perhaps, because one of these 3 judges is going to retire. Maybe the year after it will be again 3. We don't know about that. And if the case comes up to a court of appeal, then we have several judges who are very familiar with intellectual property issues and who are working at the court of appeal. But they will not be necessarily the judges who get to solve the case. Because at the Court of Appeal, the cases are divided randomly between judges. So it could happen that there are 3 members at the board, but none of them is really familiar with IP cases. So, and here I have shown you some statistics about the cases, court cases, intellectual property cases that we have solved during recent years. And you can see again the number of cases has slightly increased during last years. But I can also say that these cases are predominantly either trademark cases or copyright cases. And you can see one strange thing over here, because in 2014 it is mentioned there was one case that was sold in another court, not in our court, but that was due to the fact that the law has changed recently. In earlier times, there could be that infringement cases were decided in some other courts rather than our court, but the law has changed, and I think the aim of it was to get better quality decisions. I don't know if this is really a fact or not, but this is the system now. And before we can come to our actual cases, I also want to mention that if there are 3 specialized judges in Estonia, then you cannot say that that all these 3 judges are doing only intellectual property cases, because we are solving much more cases than these numbers. For example, in 2015, we had altogether at Harju County Court more than 14,000 civil cases. In 2017, it was next to 15,000 cases. So it means that if I'm doing intellectual property cases, I am doing other cases as well. I'm doing damaging cases and insurance cases, and that is the same with all other judges who are dealing with intellectual property issues. And of course, this is the reason why we haven't even thought about in Estonia of establishing a separate intellectual property court. So, I am talking about cases that has been decided by our Supreme Court during last 5 years. And also I am intending to tell you a little bit about some cases of the Court of Appeal. And I shall start with trademark cases. Yeah. Maybe you are aware of that there is a famous company called Zara who is producing clothes, and I think that they're in Riga. There are several shops of Zara. And Zara has community trademarks. And Zara was a plaintiff in this case. And Zara claimed that, well, we have a well-known trademark and we want to register our trademark on a new area for new goods, and we want to come to the market with grocery products, and we want to register our trademark for these products. But we are unable to do that because there is another registered trademark that was called Delizia Zara, and that was registered for pastas. And they were not able, Zara, as clothes producer, was not able to register its trademark, and they brought the case to the court and said that the defendant has not used its trademark for a long time, so that's the reason why this trademark should be extinguished. So the Court of First Instance agreed with that. They satisfied the claim. The Court of the Appeal Court annulled the decision of the First Instance, and it came up to a Supreme Court. And the Supreme Court started with a reference to European Union Directive 2008-95, and they said that according to this directive, it is essential to require that registered trademarks are actually used, and if they are not used, they should be subject to revocation. And they also made reference to the Article 12 of this directive and stressed out that if trademark is registered, it should be used continuously, according to this article, and there should be, and if the trademark is not used, there should be proper reasons for not doing so. And in the light of this understanding, they said that the notion of interesting person should not be defined too narrowly. What was the point here? The point was that the Court of Appeal said, well, the plaintiff, Zara, has not really provided evidences that they wanted to register their own trademark in the food or in the area of grocery products. So the Supreme Court said that the Trademark Act doesn't provide a definition who is the interested person, but it should be someone whose rights and obligations are affected by the actual registration. And they said that the plaintiff was really an interested person and was they could come to a court and they shouldn't provided any evidences that they really intended to register their own trademark. So the next case. The next case is a case where there was a plaintiff, and this is MTU, it means non-profit organization, who owned the community trademark. And you can see that the trademark is written down here. And they filed a claim against the defendant, who was SA, it means the foundation. And they said, well, the foundation or the defendant has registered a name, and this name contains similar words as Venemuseum or Ruski Muzey, the same words that are contained in the trademark. So they shouldn't have this kind of name. The defendant failed to answer to the court claim, so the court issued a judgment by default, and then the defendant woke up and contested the decision. And the case went up to the Supreme Court. And first of all, the Supreme Court again made reference to the Council Regulation 207/2009 about the community trademark, because it was a community trademark, and said that, well, if the applicant wishes to state that his or her trademark rights are violated, it is important to show that the identical or similar sign is used in the course of trade. So, if the sign is used in a private sphere, this is not a violation of trademark owner's rights. And they also said that the plaintiff should provide evidences that the defendant has used the sign to label some goods or services. And they also said that if there is just a name of a legal entity, then the aim of a name is just to identify this legal entity. Of course, the name can be used in relation with goods and services, but this is up to the plaintiff to show it, to prove it. And the aim of trademark in itself is not to differentiate goods or services. And if it's just a name, then it doesn't mean that the rights of trademark owners are violated, because the functions of trademark are not violated. And the Supreme Court also noted that in this particular case, it wasn't even a commercial legal entity, it was a foundation, as I said. Estonian law says that if you want to register a trademark for a commercial legal entity, then you cannot register a trademark that contains words protected as trademarks. But the law regulating registration of foundations doesn't have that provision. The law regulating registration of foundations just said that the name of foundation shouldn't be misleading, shouldn't be against good morals, and so on. So it wasn't really a clear ban for the defendant to register such name. And at the end of it, the Supreme Court said that the plaintiff had to explain in what way or manner the defendant actually used the disputable sign. So, next case. And this is a case where it was a domain name registered. The defendant had registered a domain name that is written up here. And the plaintiff said that, well, the defendant is violating my trademark rights because I have registered trademark already some years ago. And the plaintiff was a legal entity that was developing a living area, a residential area, under the name of Meskimeldre. And they claimed that the defendant knew it and the defendant has registered its own domain name, and this domain name was actually not connected to any website, but it was redirected to the defendant's own website, and the defendant was also a real estate company who on their own website advertised its own services and its own products and not the ones of the plaintiff, of course. What the defendant said, well, we have actually started already in 1996 area development under the same name, and we have used our domain name already from this time, from 1996. So we had a registered domain name that was older than the registered trademark. And they said that, well, they filed a counterclaim and said that the plaintiff has registered its trademark in a bad faith, because they could have come up with a new name, and they knew that we had this name. And they also stated that not only the registration of a trademark was made in bad faith, but also they filed a claim to the court in a bad faith. And the court of first instance satisfied the claim. It didn't satisfy the counterclaim, but the Court of Appeal did not satisfy neither the claim, neither the counterclaim. And the Supreme Court said, first of all, if there is a trademark that is registered, and the trademark owner says that identical sign is used for identical similar services, then first thing you should do, you should assess whether there is an infringement. And the courts hasn't really do that. And the identical or similar sign should be used in commercial activity, of course, and relation with goods and services, of course. The second thing, what the Supreme Court says, that domain name in itself, it's not something that is meant to differentiate the goods or services, but it is a tool. It's a part of internet name that allows to advertise sometimes services, advertise goods, and affect people to look upon to the website on some legal entity to show their goods and services. And of course, if the domain name is similar or identical to a registered trademark, it could, of course, violate the rights of a trademark owner. And they established that in particular case, the defendant really used the disputable sign in order to advertise its own services. And again, what is also very interesting that Supreme Court says that if you have registered a trademark and if you file a claim to the court, this kind of conduct cannot be regarded in itself as something that is against the principle of good faith, because it's legal, it's totally legal to register a trademark. And if the defendant says that, well, there's something wrong with the trademark, the defendant should use the legal tools that is prescribed under the trademark law. So to say that, well, there is something wrong with the trademark itself, and not just to say that the registration was against good morals or good principles. And of course, also they said that even if there is a domain name that was registered earlier than a trademark, then it's still the trademark owner who can say whether they agree with that or not. They can still turn to the court, and they can still file a claim against this domain name. And rules regulating registration of domain names are not binding for the court. I think that the defendant said in this case that, well, we have an earlier domain name, we have registered this already several years ago. How could this trademark owner say today that we are violating something? But this is really irrelevant. So, we have covered now the trademark cases, and we have came to patent cases. We haven't had that many patent cases at our Supreme Court. But this patent case is actually related to an analogical case that was solved by EPO and by the decision of 07/07/2011. And that was actually a dispute regarding pharmaceutical. It was a contraceptive pharmaceutical, and it was a pharmaceutical that contained drospirenone. If you know, there is a chemical subject like that, drospirenone in a micronized form. And the plaintiff filed a claim, and they wanted to state that there should be a revocation of a patent because it's not new. It's there is a lack of novelty as well. And the Court of First Instance satisfied the claim. The Court of Appeal also satisfied the claim. And the case went up to Supreme Court. But the Supreme Court made a very funny decision in this case. The key issue in this case was that both parties provided a lot of evidences. They had a lot of articles. They had both of them presented different expert opinions. But they also requested that the court should appoint its own expert to assess the case. And you have to bear in mind that in Estonia, we don't have technical judges. You know, all the judges who are solving the cases at the Court of First Instance are lawyers like me. So it's obvious that you have difficulties in solving technical issues. So the party says, well, that the court should appoint their own its own expert and to evaluate the case. But the Court of First Instance didn't do it. The court stated that, well, there is enough written evidence and we shouldn't have any court-appointed expert. And the Supreme Court didn't agree with that. And they said that there were technical issues in stake and the court should have had expert assessment. I think that the reason behind that was really the point that there were no technical judges and the Supreme Court wanted to be sure that everything is done kind of by the book. But the outcome of it was really that the case was sent back to the Court of Appeal, and the Court of Appeal appointed an expert, and the judgment was actually the same. And the key issue in this case was that, one of the key issues was that the patent lacked novelty. And the reason for that was that they had clinical researches made in United States, I think it was, and they didn't conclude confidentiality agreements with people who took part in these clinical researches. So they say that this is the reason why the information could have been accessible for the public. And the people who took part from the researches, they could have handed over tablets they received and so on. And it was not important whether this actually happened or not. And what also Court of Appeal said that in this case, of course, the defendant put a finger on this EPO decision I mentioned earlier. There was an analogical dispute in EPO and said that, well, Estonian court should make the same decision because there are analogical cases, analogical patents. And the Court of Appeal says, well, this is not, if you provide me a decision of European Patent Office, this is not an evidence. Yeah, Estonian court doesn't have to take this into account, but it is a source of interpretation of law. Estonian law is similar to, we are members of European Patent Convention, and this is a source of interpretation, and of course we have to interpret the law in the same manner. So, yeah, that I already spoke. Here are the outcomes of the Court of Appeal. So you can, if you are interested in these cases, you could just read them afterwards. Next case, which is merely a technical issue, but it has been one of the patent cases, so that's why I have put it up here. There was a patent owner, really, who have just failed to pay fee for validity of a patent. That could happen, you know. They had forgotten. And the patent office made a decision, said, well, patent is not longer valid. And then they turned to the patent office and said, well, it was a human mistake. Could patent office change its decision? And the patent office did not change its decision. And then they had a problem because the law didn't say what to do now. Where should they go? And they turned to the civil court directly, although the Estonian patent law doesn't say where to go in these kind of issues. And the Court of First Instance said, well, this is not the right place. You should have turned to the Board of Appeal first, or maybe even not. And then the Court of Appeal said that, well, as far as it is a decision of a patent office and it's not anything, the law doesn't say where the applicant should turn, then the applicant should really turn to the administrative court, because this is an administrative decision. But the Supreme Court did not agree with that and said that according to Estonian law, all patent disputes should really be solved at the Board of Appeal and at the civil court. So the law was changed a couple of years ago, and the law states now that it's upon civil court to solve all patent issues, and the applicant in the current case should be treated as any other patent applicant. So it meant that they should have first turned to the Board of Appeal, and then if they were not happy with the decision, they could have turned to the court. So that was the outcome, a very technical one. So, and there have been one patent issue that has been brought up to a European Court of Justice with a preliminary ruling. I don't know if you are aware of that. And here you can see the number of the case. And it was also a very interesting case. There was a plaintiff that was a large company producing pharmaceuticals again. And they had medicinal product, Xeloda, and they had also patent, and they had supplementary protection certificate, SPC. A patent was issued in Estonia in 2001, and they got the first basic patent was issued in 1998, and then 2001 they get SPC in Estonia. What is important to mention here that this SPC was issued in Estonia before Estonia became a member of the European Union. Then there was a defendant. Yeah. Then there was a defendant. Defendant was also a company for pharmaceuticals. And they produced generic products, and they wanted to come to Estonian market, and they also got their product into a list of pharmaceuticals that are subsidized by the state. So it meant that they could come to a market with the same product with much lower price. And the plaintiff filed a claim and said that, well, if the defendant comes to a market, they are violating our rights from patent and our rights from SPC. And the plaintiff requested for preliminary injunction, and they succeeded in that. And then the defendant contested that and said that, well, you do not have longer patent rights anymore. And what they were referring to, they're referring to an earlier decision of European Court of Justice that said basically about the regulation of 469, 2009, that if you have an SPC together with a patent, then your rights should not be protected for longer period than 15 years from the first marketing authorization that was granted in the European Union. So that was the defendant said, well, if you take into account your first marketing authorization, your rights have already been ended in 2013. You don't have rights to be protected at the court right now. So the case went up to the Supreme Court, and Supreme Court said that, well, we have to turn to the European Court and ask questions. How should we interpret the law? And the first thing that they asked about the same regulation, and they asked, should this Article 21 be interpreted in a way that if there was marketing authorization granted for a product in a state that wasn't a member of the European Union by that moment, should the protection still last for 15 years? Yeah. And they also asked the second question. That was very interesting. If the answer to the first question is affirmative, is the Article 21 of the regulation compatible with European law, in particular the general principles of European law and the prohibition of retroactive effect of law? So they were basically asking whether this article or regulation is in force. And the European Court of Justice analyzed the second question first. And first they said, well, okay, we can provide preliminary rulings, but we do not have a jurisdiction to rule the validity, of certain articles in the regulation. But regarding the first question, they said that, well, it's not important where the first marketing authorization was really granted, and you should interpret the regulation in a manner that the whole protection period should not be longer than 15 years. So that was the outcome of the final result. And, well, about the outcome of the result, of course, when this came out, then all of a sudden we didn't have no claim and no counterclaim. So both of the parties withdrew their claims, and the dispute continued about litigation costs. So now we have already covered all the patent cases, and I can come to copyright cases. And we have had quite many copyright cases. The first copyright case is actually related with Latvia. The claimant, or the plaintiff here, was the Estonian Authors Society. And they filed a claim against a company that was retransmitting 42 TV channels. And the retransmission was made in a way that they had a light cable, and by this light cable, signals were transmitted to Latvia, and from the Latvia they were transferred to a satellite, and from the satellite back to the Earth to the consumers who had decoding services. And the defendant said, well, we don't do anything wrong, because there have been agreements with broadcasting organizations, between broadcasting organizations and Estonian Authors Society, and we are actually acting under the control of a broadcasting organization. And we are just providing for technical services and nothing more. And the Estonian Authors Society claimed that this is not correct, because the company was different from the broadcasting organization, and it meant that they should get license fee. The Supreme Court says that, well, of course, the author has the right to decide on how the work shall be made available for the program, and if the program is communicated to the public via satellite, of course, there should be author's permission. But in this case, all the signals will enter into this communication chain under the control of broadcasting organization. So the defendant was just providing a technical service, and the Estonian Authors Society has already signed an agreement with the broadcasting organizations. And the Supreme Court also says that the law doesn't say that the author should have the right to receive multiple remuneration if the audience is the same. So it's basically in line, I think, with the decisions of the European Court of Justice. So next case, and this is a case about database. There is in Estonia a huge database for selling cars, and it's called Auto24.ee. And on this website they have car sales ads. They have also photos of cars, and if you want to sell your car, you should click that you agree with their stipulations, their provisions. You put on the photos, and within the provisions you also agree that you give over the rights to your photos. And then there came up a company who made up similar websites, and they just copied all ads from the plaintiff's website, put them on their website, and that was it. And the plaintiff claimed that, well, you have violated all our rights, because first of all, photos are protected by copyright. We have a database, we have invested a large amount of money, and database has a sui generis protection. And also they say that, well, we have also created a special computer program that is necessary to run the database. But the defendant said, well, the information as such and data you have published on your website, this is not protected by anything. And the photos on your website, they are just photos of cars. They don't have any kind of originality. They shouldn't be protected as copyright-protected works. So what the Supreme Court said that, first of all, The entire website itself, of course, is not a copyright-protected work, but the plaintiff has made a substantial investment, and the plaintiff has a sui generis right for database. So, and also the Supreme Court says that if the defendant says that the photographs published on the website are not protected by the copyright, it's up to the defendant to prove it. Just they have to provide the evidences, because if the photo once is made available to the public, it's considered to be protected by copyright. And also the Supreme Court said that, of course, according to Estonian law, license agreements should be made in written form, but the people who are using the website could also give over their rights to the photographs just clicking on the conditions, and that was okay for a simple license. And this is a very interesting case, now quite a recent one. And there was a case about, it's a similar case to this European Court of Justice case. It was about a photographer, and it was actually a very famous photographer in the United States, and she has created a series of photos, and on these photos, crying babies were depicted. And they're very, very nice photos, actually. And she made a series of these photos, and her aim when she published and made these photos was, I think, to criticize Bush administration, if I'm right. She had some political agenda behind that. And then there was an Estonian political party, and this Estonian political party had also its own newspaper. And on this website of this newspaper, they had a banner where they used one of these photos, and the photograph of a crying baby, and that was turned around, it was reversed, and they used the photo in their own, with their own political agenda. They used a photo of a crying child to show how even babies are crying because of the Estonian president, the former president. And of course, there was no indication of the name of the author, and no license fee paid, and the author came to the court. And newspapers said, well, yeah, we did use the photo, but we had no idea it was protected by copyright. And when we found the photo on the internet, it was already modified, and we don't know anything about the author. And the author hasn't proven anything. And the Court of First Instance satisfied the claim, and the Court of Appeal agreed with that, but Estonian Supreme Court thought differently. They thought that the publication of a photo in internet is basically similar with hyperlinking. And if the photo has earlier been published on the internet with author's permission, then you don't have a problem. And then they said that the court should have established whether the photo was communicated to the public with the permission of author in a manner that all internet users had access to it. So basically they said that if the whole author has communicated the photo to the public, and it was possible to not only look at the photo, but also maybe to copy it, maybe it was okay. However, they said if the photo was modified, then of course it was a violation of copyright. And also they said that the defendants are not liable if they have followed due diligence. Of course, they should have taken some measures to avoid copyright infringement, but of course, if you make a hyperlink, then a person cannot presume that a work that was initially published or communicated to the public without permission. And while assessing the due diligence of the defendants, one should take into account if they were acting in the interest of economic profit. And one interesting thing also, it was mentioned that when it comes to damages, and in that case, the author requested both moral damages and economical damages. And if you calculate damages, then the aspect of violation of moral damages should be taken into account in the lump sum, in as estimating the lump sum in taking account, and it's one part of this hypothetical license fee. And I'm very happy that previous speakers have already talked about these European Court decisions. And in my opinion, I think that the European Court's decision that was in August is more understandable for me. And I tend to agree with the European Court that if you take a photo and you copy it to your own private server and you put it on your own website, then it's not comparable to hyperlinking. And the European Court has also said that in that case, the author has lost the control over the work, because if there is a hyperlink, then hyperlink is attached to original website, and the author could always say, well, I don't want this photo to be published anymore, I should take it away. But if it's already made available on the other website, then the author cannot exercise his or her rights anymore. And of course, I think it is not relevant, and the European Court said that it's not relevant if the copyright holder initially limited in some way for the internet users possibilities to use the photo or not. It's not relevant. And actually, in more than 15 years ago, we had a similar case also that went up to Supreme Court. It's not mentioned here because it was a very old case, but in that case, it was an Estonian bank that took from internet a famous photo of Che Guevara, if you know. And there was a famous photo of a photographer, Guterres, who was living at least 15 years ago and who filed a claim against this Estonian bank. And in that case, Estonian Supreme Court didn't agree with the defendant's argument that I just found the photo in the internet and I assumed that there are no limitations. But I can also understand that by the time, the way we are using internet and the way materials are spread in the internet, it has changed our thinking as well. So I can understand both sides. And of course, there is another European Court of Justice decisions about moral damages, saying that one thing is a license, hypothetical license fee you could get from the violation of economical rights, but then additionally to that also moral damages should be compensated to author. Another copyright decision. So that was, again, a very, very strange case. There was a defendant who published a biography about a famous Estonian businesswoman. And actually, the defendant was a journalist, and he had made several interviews with several people. And one of the interviews was made with the plaintiff. And that interview was not used in large part in the book, but there were 3 sentences. And the plaintiff came to the court and said, well, I didn't say the 3 sentences. But she said that my copyright are violated, I want to get damages, and so on and so on. And the Court of First Instance didn't satisfy the claim. The Court of Appeal agreed with that, but the Supreme Court thought differently. And they said that, well, if there was an oral interview, this could also be regarded as a copyright-protected work, and the plaintiff could ground her claim on copyright violation, and it was upon the defendant to prove otherwise, to prove that this work was not protected by copyright. And another case, which is, in my opinion, a very interesting one, because it's about legal exemptions. Estonian Author Society filed a claim against a local municipality, and the local municipality was actually somebody who was responsible for activity of local school. And there was a local school who organized an Advent concert. And this concert was not held in school premises, it was held in a church. And there were a lot of different performers, not just the students and teachers, but also performers outside of the school, very famous singers, and they were selling tickets publicly. They were inviting public to come to the concert, and they were selling tickets in the internet. And the Student Also Society said, well, you should have paid a license fee for public performance. And the school or the defendant part says, well, no, this is an exemption of free use. It's an educational exemption because we are using the concert for educational purposes, and the ticket price was very, very modest. And here, Estonian Supreme Court made a very interesting analysis of the free use exemption. And they said, well, if there is a free use, then you have to see if all these 3 or 4 conditions are met. First, whether it is educational institution, if there is a direct teaching process, if there are just teaching staff and students involved, and what about the audience, if it's just teaching staff, students, or there are other people. And they came out with an analysis saying that, first of all, if you in order to have a concert for educational purposes, of course you can have it outside of the school building, because nowadays it's normal to have educational activities outside of the school building. And if you have a teaching process, then teaching processes are not just school lessons. Also, if the students are performing and showing to the parents what they can, this is also part of teaching process. But what was the problem here? They said that if you still have people outside of the school who are performing at the concert, and if you have public outside of the school, then it's not free use anymore. And then they said that in order to rely on this exemption, at least most of the performers should be teachers or students. Of course, this is a question about how much is most and how much not. And another interesting decision, again here, one of the plaintiff was Estonian Also Society together with Estonian Performance Association, and they filed a claim against the Estonian government, and they requested for damages, a rather big amount of damages. And that was actually an administrative case. And what was the issue here? They said that the government had issued a regulation for compensation related to private use of audiovisual works and sound recordings. The blank tape regulation, really. And they said that this government regulation has been has become into force since 2006. And during almost 6 years, this regulation hasn't been changed. The problem was that initially you could get payment only for these equipment objects that were listed in the regulation. For example, audio cassettes, VHS cassettes, DVDs, CD-ROMs. But the time went on, and for example, Blu-rays, USBs, mobile phones, nothing like that was mentioned in the regulation. And the actual sums the organizations got from the government, they went down because people used different recording machines, recording possibilities. And the Supreme Court says that yes, it's true, you could get remuneration only for these devices that are listed in the government regulation, and the regulation hasn't changed for many years. But the regulation is adopted in accordance with the Information Society Directive, and the directive says that the author should get fair compensation. And the wording of Article 5 is so clear that it guarantees rights for private persons. So it meant that these organizations could come to the court and request for damages if the fair compensation was not granted for them. So, and the member state has no discretion to think, well, we shouldn't guarantee fair compensation. The fair compensation shouldn't be given. And the Supreme Court also provided for some guidelines how to calculate the damages. Of course, Fortunately, the outcome was that the plaintiffs didn't get 800,000 euros, but they get a little bit less. 88,000 was the final outcome. And I'm running out of time, but I tried to at least cover the Supreme Court cases. And this is a case that hasn't had a final outcome yet, but we have a Supreme Court decision. And there was a plaintiff who requested that the defendant should give over Google AdWords account and also Facebook promotion account. The problem was that there were two parties. They made an agreement, and in the agreement it was said that all rights to copyright-protected works should be transferred to the plaintiff. So, referring to that, the plaintiff said, well, I want these accounts to be given over. The defendant said, well, I don't have any such obligation because Facebook accounts and Google work accounts, they are not copyright-protected works. And works protected by copyright were ad campaigns and analysis, and all this material has already been transferred to the plaintiff. So, as I explained. And the Supreme Court said, well, first of all, it is important to establish what actually could be given over and whether these accounts were actually created and what kind of information or what kind of thing the plaintiff could really request. And the Supreme Court also says that basically, well, it is possible that accounts are protected by protected as copyright-protected works, but in that perspective, they have to be expressed somehow in an original objective form. And if there is just data as such, you cannot say that this is copyright-protected work. But I cannot imagine in my real life how could, account be expressed in original objective form. And what they also said that if the defendant said that, I cannot give over access to these accounts because they are containing my know-how and trade secret, they have to prove that they had any know-how or trade secrets at all. So, and in very few words, I should cover these some examples of Court of Appeal decision. This was actually a patent case, and why I have put it up here is not because of the dispute itself, but there was a case where a patent application was filed and thereafter changed. And the opposite party filed an application stating that this patent has been changed and it couldn't have these kind of changes. And what was the problem here? The problem was that the judge who dealt with this case at the court of first instance was an exceptional person who had both technical education and legal education. And the judge evaluated technical issues himself. So the parties went to the Court of Appeal and said, well, this is wrong because the judge cannot take into account technical arguments, just legal ones. But the Court of Appeal says, well, no, it's possible. So the next thing is a trademark dispute, and that's an interesting thing. That who is again an interested person filing a claim in cases of trademarks. So this was the case where there was a similar trademark dispute in Finland, and a plaintiff came with a claim against defendant, saying that I am an interested person because there is a similar case in Finland, and in that case the Supreme Court says, well, this is not okay. You have to prove a little bit more than that. And this is an interesting case. There was a registered trademark. And when you put this registered trademark, there was a word trademark in Google, the first thing you could see, you could see the website of the defendant with a totally different name, but they had paid to Google for Google AdWords in order to get their website as a first result of the research. So the plaintiff sued the defendants, and the defendant said, well, the signs, the trademark and the sign we are using are totally different. But the court said, well, if you use this Google AdWords service, it could violate the rights of trademark owner. And this is a case where there was a plaintiff who had a trade name, a very old trade name, and they filed a claim against trademark owner, saying that, well, trademark owner who had the trademark registered for his goods and services is using the trademark as well as trade name, and the defendant shouldn't do that. And the Court of Appeal said, well, the trademark owner has always the right to use its trademark for goods and services, and if you want to file any claim against the defendant, you have to show that he or the defendant is using a trademark as trade name, which was not the case in present issue. And here is a very typical case. I don't know if you have had these kind of cases also in Latvia, but from Soviet times we have had in Estonia many food products that are having the same names as the food products had during Soviet time. One very famous cheese was, for example, Russian cheese. Venajust is the example of that. And this is a cheese product that has been that has had the same taste and flavor throughout many years. And there was a plaintiff who registered figurative trademark containing the words Russian cheese or Venajust. And then there was a defendant who registered also figurative trademark containing the same words. And then the plaintiff came up with a claim against the defendant. But the court stated that, well, these words Russian cheese, Venajust, they are not protected by the trademark, but they are rather something that could see the type of a good, type of a product. And yeah. And this is also a very interesting one. There is a Student Also Society claim against a sport club, and there was a sport club who had training lessons, used music, but didn't pay for that. And they claimed, the defendant claimed that, well, we are a non-profit organization. Our fees are lower than these for other sport clubs, and we are also teaching youngsters and children, so we can rely on educational exemption. We don't have to pay for the music. But the Supreme Court didn't agree with that and said that, well, if the fees are lowered, this is not an argument. And if you have some license for teaching children and youngsters, this is also not an argument. And this is the last thing I wanted to say. And this was also referred by one of the earlier speakers. This is the preliminary ruling request sent to the European Court of Justice by Estonian Court of Appeal. And that was actually also a very interesting case. And there was an applicant or the plaintiff who said that we are a collective representative organization of trademark owners, and they filed a claim against the person who had registered several IP addresses, and the plaintiff said that on these IP addresses you could find websites, and on these websites counterfeited goods are sold, and the plaintiff requested for damages. But the problem here was that the plaintiff couldn't show that he or she had any rights to turn to the court directly, because the plaintiff didn't own any of these trademarks, and they didn't manage to prove that they have authorizations from the trademark owners. And I think in the end of it, they said, well, we don't need, because we are a collective organization, and that's it, that's enough. And of course, then the defendant said, well, I don't know anything about the domain names and websites. I just owned IP addresses and I rented them out, and I don't know what happened afterwards. So that was the reason why the European Court of Appeal requested the preliminary ruling and asked two questions that are up here, how the law should be interpreted. And the European Court of Justice said that the answer to the first question, how should we regard these collective organizations, they said, well, it's up to your own law. It's up to you to establish whether it's allowed under Estonian law to this applicant to come to the court or not. And regarding the second question, they said, well, of course, it's again up to a Estonian court to identify the circumstances, whether the defendant was aware of these things that were going on these websites or not. So I have a little bit misused my time, but finally I would like to say there is one thing I like about intellectual property issues is that it's changing all the time. Issues are changing, disputes are changing, the world is getting more technical and more complex every day. So thank you.